Hi, Michael, and hello, everyone. I'm with Michael Wynn today, a lawyer of Dunedin and a partner at Wilkinson Rodgers, local Dunedin firm. And Michael's covering off a series of topics for us, legal topics, that are basic to anyone's financial plan. And the topic today is enduring powers of attorney. What are they, Michael, and why do you need them?
Enduring powers of attorney, where someone appoints someone to act for them when they aren't able to make their own decisions, or where they're unable, they might be overseas or temporarily incapacitated by an accident or something like that. So you've got someone who can always look after your affairs when you can't. So there's two forms. They're called enduring powers of attorney. The enduring bit means that it endures your mental incapacity. So if you lose your mental capacity, these carry on. So the two types, one for your personal care and welfare, which is really...
Michael, can I just ask you, what's mental capacity?
Mental capacity is when you can't rationally make decisions that that a normal person would. So you can't, it often happens with dementia or that sort of thing, or brain injuries where people can't rationalize things. They couldn't do what's in their best interests. Yeah.
Okay, now I interrupted you, sorry. Yep. So
no, that's fine. So we've got the two forms. The personal care and welfare one is really decisions that can be made for your medical treatment mainly. But this form of power of attorney only gets activated if you are certified by a doctor as not having a mental capacity, right? So it sits there dormant. Once you make it, sits there dormant until such time. One hopes that it never gets activated, but if it does, whoever you have appointed to act they'll act in your best interests and will make the decisions, things on where you've got to live if you go into care and all your medical treatment and surgery, those sorts of things. There are restrictions on what that person can do, but I won't go into that. Yes. So there's also the other form is property, and it's different in that most people would have their property power of attorney activated at all times rather than just when they become mentally incapable. The reasons for that are that you may have gone overseas on holiday and say lose your Visa card, and so you've got someone in New Zealand that can pop into the bank who's your attorney under your power of attorney and sort it for you, or pay bills or whatever. The other use we see where people have still got their capacity, but they can't, they've become elderly and a bit infirm and don't want to be dealing with paying bills and things. That you've got someone, your child or whatever, that's your attorney who can do that work for you.
So by property, Michael, what do you mean?
Okay, so property, most people will think, oh, it's where I live, but it's not. It's everything that you own.
Right, everything
the person owns, and whoever makes the will and the power of attorney, it's whatever they own. So it's nothing. It doesn't cover anything that's in the company or a trust. Right. So another thing that people need to be aware of when they're making the powers of attorney are who owns what property. A couple may have investments, and some of the investments may be in the name of one of the partners, one spouse, and not the other, but they're both living off that. So under the Act with powers of attorney come under, that only makes provision for jointly owned property.
Oh.
So if you've got a couple who are living off the assets of one of them, yes, then you need to make sure that the power of attorney covers that. Otherwise, you don't have any legal access to those funds.
Oh, it can get tricky. Really, it can get tricky, Michael.
Very tricky.
It can get tricky. But I can see absolutely essential because again, if you leave it, if you don't put this in place in time, once you are unable to make your own decisions, it's too late.
It is too late.
And
Yes,
it can become expensive.
Yes, yes. You have to have capacity, mental capacity at the time you make them, and that's for the lawyer to judge. And if we have any doubts, we generally ask the person to be assessed. If it's found, I mean, some people have memory losses and things, but they've still got capacity to do this because they'll have lucid moments. So the threshold is reasonably low, as long as they know what they're doing. It's okay, but it's on a case-by-case basis. There's no strict rule that covers everyone. But as long as they do seem to have capacity, they can make their power of attorney. If they don't, of course, if something happens to them, they do lose capacity, then someone's going to have to apply to the family court to be the manager for that person. And it's often generally lawyers are appointed, and they have to report to the court, and it's an expensive process.
Oh, yes. Yeah.
Yes, best avoided. Spend a little bit up front, and so you're protected.
Of all the things that we do as financial advisors, reminding people, asking people if they have enduring powers of attorney in the first place, then finding out that they haven't, asking them to go and do it, emailing their lawyer, reminding them at the first anniversary, reminding them at the second, third, fourth, fifth anniversary. We've gone on 10, 20 years and people have not seen it as that important. And I've just been involved in a case where the final trappings of their power of attorney, enduring power of attorney, were designed days before they became incompetent, hours before they became it. And it's so sad because in this case, there's a lot of money involved. It nearly didn't happen.
I mean, it's a real risk. Yeah.
So how old, what age should someone put an enduring power of attorney in place, Michael?
20.
Yes.
Yes. But anything past 20, a lot of people think that, it's only for old people, but it's not. It's for anyone. I don't know, unfortunately spend a bit of time seeing people in rest homes, and it's amazing how many younger people are in there who've had medical events or accidents and require full-time care. So you don't have to be elderly to need powers of attorney. You never know if you're going to have a medical event or something that's going to
We had a relatively young client at a car accident and happened to have an enduring power of attorney.
Yes.
But and that's been a lifesaver. But most clients when we meet for the first time don't have them. Yeah.
It's becoming, some institutions are requiring them now. Like if you go into a rest home or a retirement village, it's a requirement. You must have them.
Yeah, I can understand.
Which is good. But even hospitals and things now are starting to push for it. So it's at some stage in the future it'll become more commonplace than it is at the moment. But it really is an important tool in the protection armory.
And it's a reasonably recent act, isn't it, Michael? It's been updated.
It's 1988 Act, but it's been updated several times.
Since then?
Yes. So the powers of attorney, the forms themselves are now a standard government-issued form, so everyone uses the same one. Yeah. And that came in March a couple of years ago.
Yeah.
So everyone has to use the same thing, so everyone knows what it's about. And they've produced some standard explanations, which you can actually see online if you just Google it. Comes up, the Ministry of Social Development have a website that has them on it, so people can read all about what are the things I should be considering.
Yeah, I mean the forms are a bit onerous, aren't they? I mean, I think it's 14 or 15 pages long, and it takes you do need a lawyer to help you navigate through them. And I remember I did some enduring powers of attorneys, and they weren't done properly. And we had to, a year later, someone found out they hadn't been done properly, to do them all again.
Right. So
it pays to get this done and get it done properly.
Get it done, do it once, do it properly.
Yes.
I mean, there's lots of things that people wouldn't think of on the way through. You know, a lot of people, you know, point each other and they might be 80. Well, what's the point in that?
Yes.
And not think about, you know, what happens if we both become mentally incapable or one of us dies.
Yes.
You know, you've got to think through consequences.
Yes.
Yes.
And a lawyer will guide you through that, because you would appoint your spouse, but then if they're not capable, then you would appoint someone under them, and perhaps even a third.
That's right. Yes, you can put successors, and so you've got a chain. Well, generally don't go beyond one, but you can put two, just to make sure that you're safe. Because, you know, if you do lose your mental capacity, lose the plot, whatever you want to call it, then it's too late. You can't change anything.
No.
Yeah.
Well, thank you, Michael. I mean, that's a brilliant topic. I mean, I think it's brilliant, because it's a part of the work we're doing all the time, is reminding people to do this, pushing them along. It's an essential tool, like a will. And I think that's a really good summary. So thank you for your time, Michael.
Thank you, Rose.
And we'll sign off there.
Okay.
Thank you.